Hello everyone, my name is Isaac Emil Peter Lutz, and today I'll be presenting on the disparities between monist and dualist legal system and its application as to the approved multilateral environmental agreement on the issue of climate change. Furthermore, I'll be explaining as to the possible legal and practical challenges that each system encounters. Lastly, I'll be providing recommendations in order to improve consistent adherence across various legal systems. The monist legal system views international law and national law as part of a single legal order, with international law automatically being part of the national legal system without domestic legislation. In other words, it can be said that international law is superior to national law. Sir Hersh Lauderpash has stated that a monistic version to be more precise in solving the problem of gaps of international law. In some monistic states, treaties must have binding force, be approved by Parliament, and be made public for legal certainty. In the Netherlands, treaties that become binding automatically becomes part of the legal order of the kingdom, but approval by Parliament is not required. Article 93 and 94 of the Netherlands Constitution allows treaty provisions to be applied by courts and given precedence over conflicting domestic laws. The dualist theory suggests that international and national law are separate legal systems, with little integration between them. To incorporate international law into national law, it must be converted through national legislation. This approach emphasizes the state's importance and the role of Parliament in ratifying and incorporating international agreements into domestic laws. The dualistic approach is positivistic in nature, where stresses the overwhelming importance of the state. In the case of Glenister and the President of the Republic of South Africa, the court further explained on the application of the dualist theory, in which the making of international agreements falls within the province of the executive, whereas the ratification and the incorporation of the international agreement into our domestic laws falls within the province of Parliament. The Vienna Convention on the Law of Treaties fortifies this dualistic approach, stated that treaties do not automatically become part of state laws unless domesticated through national legislation. Countries like the United Kingdom and India practice this dualistic approach, with the Indian Constitution as per Article 253, read with entries 13 and 14 of List 1 of the Indian Constitution, requiring enabling legislation from Parliament before international agreements can be enforced in the domestic legal system. The monist approach applies the incorporation doctrine, stating that international law has validity only if its principles are accepted by domestic laws. This doctrine is based on the Chung Chi Chengu and R case, where Lord Atkins stated the existence of rules among nations and treat them as incorporated into domestic law. The transformation doctrine, on the other hand, requires express state adoption of international law. The disparity that exists in terms of incorporation highlights that there is a higher degree of uniformity according to the monist approach, but only to a certain extent. Monist systems, by directly incorporating international treaties into domestic law upon ratification, often achieve a level of uniformity in compliance. This is exemplified by Netherlands and Uganda Foundation, where the Dutch Supreme Court enforced the government's obligations under the Paris Agreement, mandating a 25% reduction in emissions from 1990 levels. This case highlights how monist systems can promote uniform compliance, as treaty provisions become immediately enforceable in domestic courts. However, uniformity does not guarantee effective implementation. For instance, in Costa and ENEL, although primarily concerning EU law, the case underscores how monist systems may face conflicts between domestic legislation and international obligations, leading to legal disputes when alignment is lacking. Similarly, in Democratic Republic of Congo and Rwanda, the DRC struggled to enforce international norms despite being a monist state, illustrating how weak governance and administrative capacity can undermine the potential benefits of uniform treaty incorporation. Thus, as states that function with a monist approach who had agreed to the multilateral environmental agreement may not comply to the emission reduction targets, as it may face conflict with domestic legislation and that weak governance may not allow the fulfillment of the state target. In contrast, dualist systems, while preserving legislative sovereignty by requiring domestic enabling legislation for treaties, often lack uniformity in compliance. The requirement for legislative action can lead to delays and selective incorporation, as seen is Crown and Secretary of State for the Home Department, ex parte Bryan, where the UK refrained from applying provisions of the European Convention on Human Rights without specific domestic legislation. Additionally, in Commission and Ireland Mox Plan case, Ireland's dualistic approach delayed its alignment with EU environmental directives, resulting in fragmented implementation. While dualist systems offer flexibility to adapt international obligations to local contexts, they often lack the consistency that monist systems are structured to provide. This contrasts with monist systems, where international treaties automatically become part of domestic law, reducing the scope for such delays. However, the rigidity of monist systems can limit legislative sovereignty and cause conflict with domestic policies. For instance, if a state had agreed to the multilateral environmental agreement, the failure to enact an act of parliament due to disagreement as to the emission reduction targets would simply nullify the transformation of such an agreement into domestic law. The effectiveness of compliance in both monist and dualist systems largely hinges on the strength of institutions and political will, as illustrated in the Beijing air pollution case. Despite China's quasi-monist approach to treaty incorporation, its robust institutional framework and strong political commitment facilitated significant progress in reducing air pollution. This highlights that effective governance and political determination are essential for achieving compliance, irrespective of the legal system. In contexts of political resistance, the dualist system often exhibits stronger resistance due to the necessity of legislative approval for treaty implementation. For instance, in Massachusetts and EPA, the US Supreme Court mandated the Environmental Protection Agency to regulate greenhouse gas emissions under domestic law, demonstrating how political and administrative hurdles in dualist systems can delay the translation of international obligations into actionable policies. In contrast, monist systems might avoid legislative gridlock, but still face resistance during the operationalization of treaty obligations, as observed in Netherlands and Uganda Foundation, where judicial enforcements of climate commitments clash with political and economic priorities. Thus, if the institution of a state, despite agreeing to the agreement, may nevertheless not adhere to it due to inability to comply with the targets, or other factors may come in place, such as transition in the government of the day. One challenge that the monist approach encounters in harmonizing domestic legislation with international commitments involves conflict between domestic laws. With direct incorporation of international obligations, the obligations would contradict with existing domestic laws governing within the state. In the case of Costa and ENEL, a case in the European Court of Justice, Italy, a monist state under EU law, faced a conflict between its national legislation and EU treaty obligation. Article 10 of the Constitution of Italy, 1947, further states that the Italian legal system conforms to the generally accepted rules of international law. The court emphasized the primacy of EU law, illustrating how treaties can clash with domestic laws. Similarly, environmental treaties can impose obligations that conflict with existing policies or industries, leading to compliance delays. Secondly, a nation with a monist approach would have a strong public and political resistance, as due to its deemed automatic adoption may cause disagreement and setback at a legislative level. A notable example of how public and political resistance to a state's agreement to be part of a treaty is the United States' withdrawal from the Kyoto Protocol. The protocol, adopted in 1997, committed industrialized nations to reduce greenhouse gas emissions. Although the US signed the treaty, it was never ratified by the Senate due to the significant political and public opposition. One key factor was the Byrd-Hagel resolution, passed unanimously by the US Senate, which stated that the US should not join any treaty that mandated greenhouse gas reductions without similar commitments from developing nations such as India and China. Critics argue that the treaty would disproportionately harm the US economy, particularly industrial reliant on fossil fuels, while giving an unfair competitive advantage to developing countries not bound by similar restrictions. Public resistance also stemmed from concerns over the economic impact of emission reductions on jobs and energy prices. This combination of political opposition and public skepticism ultimately led to the US refusing to ratify the Kyoto Protocol, despite being one of the world's largest greenhouse gas emitters, highlighting the challenges of aligning international commitments with domestic, political, and economic and legal realities. With a strong public and political resistance, it will be a hurdle for a state with a monist approach to harmonize its domestic legislation with international commitments. As per a state with a dualist approach, legislatures may adopt only a portion of a treaty, leading to a partial or fragmented compliance with international commitments. An example of a dualist state selectively incorporating a treaty is the United Kingdom's approach to the European Convention on Human Rights, ECHR. While the UK ratified the ECHR in 1951, its provisions were not directly enforceable in domestic law until the Human Rights Act 1998. Even then, the incorporation was selective. The Human Rights Act made specific rights from the ECHR enforceable in the UK courts, but maintained parliamentary sovereignty, allowing the UK to decide whether to amend the legislation deemed incompatible with the Convention. For instance, in cases involving prisoner voting rights, Hurst and United Kingdom, The European Court of Human Rights ruled that the UK's blanket ban on prisoner voting violated the ECHR. Despite this, the UK Parliament did not fully comply with the ruling, reflecting its selective incorporation of ECHR obligations into domestic law. This example illustrates how dualist systems may choose to adopt only parts of a treaty or retain the discretion to deviate from international rulings, balancing international obligations with domestic legislative priorities. Thus, it provides an upper hand to nations with a dualist approach. Adopting every clause of the agreement except the required emission reduction targets can be an option. However, what lies ahead would be scrutiny from various parties should the target be omitted or unfulfilled. Lastly, economic pressures pose significant challenges for dualist states like India in harmonizing domestic law with international treaty obligations, particularly when these commitments demand substantial policy shift with financial and societal ramifications. For instance, under the Paris Climate Agreement, India pledged to reduce its carbon emissions and transition to renewable energy. The Paris Agreement 2015 is a global climate agreement requiring all countries to get emission reduction targets, known as Nationally Set Determined Contribution (NDCs), to prevent global temperature rise above pre-industrial levels and achieve global net zero emissions by the second half of the century. China and India are now among the world's top annual emitters, with the latter emitting 166 billion tons of carbon dioxide since 1850 and of 2021, along with the United States. Developed countries have argued that those countries must do more now to address climate change. Meeting this obligation required extensive legislative actions and economic restructuring, including investments in green energy infrastructure and reducing reliance on coal, a key energy source supporting small industries. This transition risks raising energy costs, undermining the competitiveness of domestic industries, and creating political resistance. One of the recommendations to improve consistent adherence across the various legal systems is by strengthening institutional and judicial mechanisms. Establishing climate courts or tribunals can enhance the consistent adherence to international climate treaties by providing a specialized mechanism to adjudicate disputes and ensure compliance, regardless of a state's monist or dualist legal system. These judicial bodies would address gaps in enforcement and harmonize obligations across jurisdictions by interpreting treaty commitments in line with global standards while considering domestic legal frameworks. For dualist states like India or the United Kingdom, where treaty obligations must be translated into domestic law, climate courts can monitor implementation, ensuring laws align with treaty goals and holding governments accountable for non-compliance. On a global level, the proposed International Court for the Environment, akin to the WTO's dispute resolution mechanism, could serve as a model to resolve conflicts arising from climate treaty breaches, ensuring states, regardless of their legal system, comply with their international obligations while fostering a uniform global approach to environmental governance. The second recommendation is by incorporating binding but flexible enforcement tools, such as penalty-linked financial mechanisms and trade measures, which can significantly enhance consistent adherence to international environmental treaties across both monist and dualist legal systems. Penalty-linked financial mechanisms, where non-compliance incurs fines, balanced by incentives for exceeding targets, create a system of accountability while fostering collaborations. For instance, under the Montreal Protocol, trade sanctions were used effectively to ensure compliance in phasing out ozone-depleting substances, demonstrating how economic leverage can incentivize adherence without undermining national sovereignty. These penalties, coupled with financial support from the multilateral fund, allow developing nations to transition to compliant technologies, striking a balance between enforcement and equity. Similarly, these measures, trade measures tied to compliance, such as preferential access to markets for countries adhering to climate goals, could be applied under agreements like the Paris Climate Accord. For monist states like France, such measures can directly reinforce treaty provisions integrated into domestic law, while for dualist states like India or the United Kingdom, they encourage legislative alignment with international obligations to avoid economic disadvantages. These tools promote uniformity by creating a shared incentive structure, ensuring that nations across varying legal systems prioritize and uphold their treaty commitments. In conclusion, in comparing monist and dualist legal systems in the application of the multilateral environmental agreements, like those addressing climate change, it is clear that each system presents unique legal and practical challenges. Monist system simplifies the integration of international law by treating it as part of the domestic legal framework upon ratification, facilitating uniform adherence. However, this can lead to conflicts with domestic laws and resistance from political entities of the public. Dualist systems prioritize domestic legislative processes, enabling tailored incorporation, but often at the cost of delays and inconsistent compliances. To enhance adherence to MEA across these systems, stronger institutional frameworks such as climate courts and binding yet flexible enforcement mechanisms are recommended. These steps would help harmonize domestic laws with international obligations, bridging the gap between varied legal traditions and ensuring greater global commitments to environmental goals.